Good morning, everyone. I'm excited to welcome you to today's presentation. We will be discussing the termination of procurement contracts based on the Public Procurement Regulations of 2064. This slide introduces the topic and sets the stage for what's to come. We'll be exploring the key procedures, legal considerations, and best practices related to contract termination. Let's dive in and explore this important aspect of civil engineering procurement. Now, let's take a look at the contents of this presentation. We have a few key points to cover today. First, we'll discuss termination for convenience, which is an important concept in contract management. Then, we'll move on to a summary table of contract termination conditions, where we'll compare different scenarios and what they entail. This overview will help us understand the various ways a contract can be ended, either for cause or convenience, and the implications of each. Throughout this presentation, we'll see how these concepts fit into the bigger picture of effective contract administration and risk management. So, let's dive into the specifics and explore each of these points in detail. Let's talk about termination for default. This is a crucial concept because it deals with what happens if one party fails to meet their contractual obligations. Essentially, if a party defaults, meaning they don't perform as agreed, the other party has the right to terminate the contract. But it's important to understand that this isn't something to take lightly. There are often specific conditions that need to be met before termination can occur. For example, the defaulting party might be given a chance to cure the breach before termination is finalized. This concept ties into the overall theme of managing risks and ensuring contractual compliance. Knowing when and how termination can happen helps us protect our interests and maintain control over the project or agreement. It's also a reminder of the importance of clear, well-drafted contracts that specify what constitutes a default and the process for termination. So, in summary, termination for default is about safeguarding against non-performance, ensuring that the contract can be ended if necessary, but always following proper procedures to keep things fair and transparent. Let's take a closer look at some key conditions that can lead to contract termination. First, if a contractor fails to perform the work as specified in the contract, the public entity has the right to step in and terminate the agreement. Essentially, this means we can end the contract and have the remaining work completed at the expense of the defaulting party. Next, there's the issue of exceeding the period for liquidated damages. If the delay in performance reaches the maximum limit for which liquidated damages can be applied, usually capped at 10% of the contract price, the contract must be terminated. This helps ensure that delays don't go unchecked and that there are clear consequences. Another important point is about extending the contract period under special circumstances. If, under the provisions of Rule 120 Hindi, an extension is possible and the work remains unfinished, then termination becomes necessary. This prevents projects from dragging on indefinitely without progress. Finally, under Rule 128(2), there are other breaches that can also lead to termination. These include more serious issues like abandoning the project, failing to repair defective work after being notified, subcontracting without approval, going bankrupt or insolvent, or engaging in corrupt or fraudulent practices. All of these conditions give the public entity the authority to take action and protect the integrity of the project and its interests. Now, let's discuss what happens when there is a termination for default. Essentially, if a party defaults on their obligations, they become liable for any additional costs the public entity might incur to complete the work. This means they could face significant financial consequences. Additionally, the performance security that was initially provided to guarantee the completion of the project is forfeited. So, the defaulting party risks losing that security entirely. Finally, it's important to note that a party found to be in default may also be blacklisted, according to Rule 141. This can have serious long-term implications, affecting their ability to participate in future projects. All these points highlight how crucial it is to meet contractual obligations, as default can lead to serious penalties and impact future opportunities, reinforcing the importance of diligent and responsible project management. Let's talk about termination for convenience. This is a clause that gives one or both parties the ability to end the contract without needing a specific reason. It's a flexible tool that helps manage risks and adapt to changing circumstances. When a party opts for termination for convenience, they typically need to provide notice according to the terms outlined in the agreement. It's important to understand that while this offers flexibility, there may be provisions about compensation or penalties, depending on the contract. Overall, including a termination for convenience clause helps create a more adaptable and balanced agreement, aligning with the broader theme of managing project risks effectively. When it comes to termination for convenience, there are a few key conditions we need to keep in mind. First, the primary reason for ending the contract must be in the public interest, as determined by the public entity. This could be due to a change in government priorities, a lack of funding, or other unforeseen circumstances that make continuing the project no longer viable or desirable. Rule 127 provides the specific procedures and payment terms that govern how this type of termination is carried out. It ensures that the process is transparent and fair for all parties involved. Another important point is that the public entity is required to issue a formal notice to the contractor, supplier, or consultant. This notice officially informs them that the termination for convenience is taking place. It's a crucial step in maintaining clear communication and managing expectations. Overall, these conditions help ensure that terminations are handled responsibly and in line with legal and procedural standards, especially when circumstances change and the project can no longer serve the public interest as originally intended. When a termination for convenience occurs, it's important to understand how the payment process works. The payment terms are designed to be fair to the contractor for the work they've already completed, but they don't cover future profits. According to Rule 127, the contractor is entitled to be paid for specific things. First, there's the work they've already performed, and that has been accepted by the public entity. This means if they've done the work and it's approved, they get paid for it. Second, they can be reimbursed for materials they've reasonably ordered and delivered to the site for the project. And third, if the contractor needs to demobilize or remove their equipment, they can be compensated for reasonable costs associated with that process. On the other hand, there are things the contractor is not entitled to. They can't claim compensation for any anticipated profits they would have earned on the remaining work that won't be completed. Plus, they aren't entitled to any other consequential damages that might arise due to the termination. Overall, this structure ensures that contractors are fairly compensated for the work and materials already committed, but it also clarifies that they won't receive payments for profits they might have expected from the uncompleted work. This ties into the broader theme of balancing fairness and clarity in contract terminations. Let's take a closer look at this summary table of contract termination conditions. Here, I've laid out the key points to keep in mind. First, notice how it categorizes different scenarios that can lead to the end of a contract. These are critical because understanding the specific conditions helps us manage risks and expectations. For example, some conditions might be tied to breach of contract, while others could relate to mutual agreement or specific timeframes. Recognizing these distinctions is essential for both parties to know their rights and obligations. This table also highlights the importance of clear, well-defined clauses in the contract. The more precise we are, the less room there is for ambiguity or dispute later on. Overall, this slide ties into the larger theme of contract management, being proactive and fully aware of the conditions that can lead to termination. This knowledge empowers us to draft better agreements and handle potential issues more effectively. Let's take a closer look at this summary table of contract termination conditions. First, when it comes to termination for default, there are specific governing rules we need to keep in mind. Rule 128(2) applies when there's a failure to perform work as outlined in the contract. Essentially, if the contractor doesn't deliver as promised, this rule kicks in. Next, Rule 121 is relevant when delays happen. If the delay exceeds the maximum period for applying liquidated damages, usually around 10% of the contract value, that's a key condition for termination. It highlights the importance of timely performance. Then we have Rule 120K6, which deals with situations where the contract can't be extended or the work isn't completed within a specially extended period. This rule emphasizes the importance of adhering to scheduled timelines and extensions when granted. On the other hand, termination for convenience is governed differently. Rule 127 allows a public entity to terminate the contract if they deem it necessary for the public interest. This provides flexibility for public authorities to prioritize the public good over contractual commitments when needed. Overall, these rules help us understand the key conditions under which a contract can be terminated, either due to default or for convenience. Recognizing these conditions is crucial for managing risks and ensuring clarity in contract management. Thank you so much for your time and attention today. I really appreciate the opportunity to share these insights with you. Remember, the key takeaways we've discussed are crucial for understanding the overall theme of our presentation. I hope you found the information valuable and that it inspires you to apply these concepts in your own work. Once again, thank you for being such an engaged audience. I look forward to connecting with you further and exploring how we can continue to grow together.